Title of today's Brandon's blog is Discharge from Bankruptcy Canada, our detailed step-by-step guide. On a fairly regular basis, we will get a phone call from someone, and the discussion goes something like this. The person tells us that they are an undischarged bankrupt and that their trustee won't apply to get them a discharge and won't help them unless they pay them more money, and they don't understand why. Well, in today's Brandon's blog, we answer that question. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. I hope you can watch until the end of this video to get the answer, because I know you will find it informative. Why would a licensed insolvency trustee not help the bankrupt person on the file they're administering to get their discharge? The answer is the trustee has a duty to help them and always does. But the trustee only needs to do that once. They only need to apply for the bankrupt's discharge once. So while we're on the phone with the person, we do a quick search of the Office of the Superintendent of Bankruptcy's insolvency database. And it turns out that the person had a discharge hearing, and either it was adjourned or their discharge was given, but with conditions, a conditional discharge, and they obviously hadn't fulfilled those conditions yet. So that's one reason why they still can't get an absolute discharge. If their bankruptcy hearing was adjourned, it is probably because the court was not happy with the evidence that the bankrupt had put in to justify why they deserve an absolute discharge in the face of either the trustee opposing, one or more creditors opposing, or both. So in today's Brandon's blog, Brandon discusses why that situation can arise, and if you're that person, it is a detailed step-by-step guide on how you can actually apply for your discharge from bankruptcy on your own. But for a layman, it is not a simple process. It is actually complex. So the person is best off hiring a bankruptcy lawyer or reaching a deal with the trustee to pay them a certain amount of money to get the file out of storage, to review the file again, to apply for another discharge for that person, and to help that person navigate the system. But if they want to do it on their own, this detailed guide will show them how. So Brandon first talks about what the implications of a bankruptcy discharge for a person in Canada means. And then he discusses what are the implications if you are not discharged. And then Brandon goes through the steps necessary for a person to get their discharge. They have to complete the application for discharge to the court. They have to prepare a notice of the hearing once the court gives them a date. They have to prepare their material, their affidavit, which provides evidence for the reasons they believe they are entitled to an absolute discharge at this point in time. They have to then serve their material on the trustee, on any creditor who opposed or otherwise showed up to the first discharge hearing, and the Office of the Superintendent of Bankruptcy. And then they have to prepare an affidavit of service proving that they served it on all those people. And they have to have all that material filed in court. And then they will have their discharge hearing before either an associate judge or the registrar in bankruptcy, or if it is opposed, before a judge in bankruptcy court. And then Brandon goes through the different types of discharges that are possible and ultimately getting their order of discharge. So I hope you can read the entire Brandon's blog below, because I know you will get value from it. Again, both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you.